In the last video clip, we talked about the land sales contract. We started the whole topic of conveyancing in property law by talking about the land sales contract. Today, we're going to talk about deeds. The land sales contract, rights under that contract, merge into your rights under the deed when you have closed escrow and accepted a deed. But step back for a minute. If you're studying for a bar exam or a law school exam, any kind of an exam in property law, have you memorized Level 1 yet, as I suggested in an earlier clip? Level 1 starts with estates and land. There are three kinds: concurrent estates, present estates, and future estates. The second topic in Level 1 is adverse possession. The third is landlord-tenant law. The fourth is non-possessory interests. The fifth is covenants. The sixth is conveyancing, and it has three main areas: land sales contract, deeds, and security interests. And the last topic is rights, water rights, and rights of support. Now, those are listed as separate topics in the organization you'll see at the top of this screen. And then at the bottom of the screen, it's presented the way I just summarized for you. That one is easier for me to memorize. If you want to memorize it as 13 separate topics in Level 1, that's just fine. Today, deeds.
Okay, so now we're away from the land sales contract and we're on to deeds. The deed is the normal and ordinary way of transferring property. Now, because this is an interest in real property, the deed must be written. And so to satisfy the Statute of Frauds, the deed has to contain a description of the property and the identity of the parties, the price, and it has to be signed by the party to be charged. And valid conveyance means, first of all, a valid deed that complies with the Statute of Frauds. We need present delivery, and we also need acceptance. Now, the law broadly construes acceptance, but present delivery is not so broadly construed. What do we need to have a valid present delivery? The issue is the intention of the grantor. We need a present intent to deliver. And once that's found, the grantor can't retract that delivery. So if the grantor announces a present intent to have someone have the property, a present intent to deliver the deed, then that grantor can't change his or her mind about the delivery.
So if you have a hypo that says the jury believes that the grantor had the present intent, no matter how ridiculous that belief, if the jury believes it, you've got the present intent and you have a valid present delivery.
But you can't have a valid present intent to deliver if the grantor retained an absolute right to recover the deed. Then there is no present intent. So for example, if the grantor hands the deed to a friend or a relative and says, "Here, hold on to this deed, and if my niece Nan does something that I like, then give her the deed." Mm-hmm. That's not present intent to deliver. So if there are conditions on it, then there is no present intent to deliver.
So father hands the deed to his son, says, "Son, if you get married, then this is all yours. Sorry, no present delivery."
So the big issue of conditional delivery. You can't make a conditional delivery to a grantee. That's what Dennis just went over. The delivery has to be absolute, and intent is controlling. The court allows parole evidence on the issue of intent in this area as well as in many other areas of the law. In wills, extrinsic evidence is allowed on the issue of intent. What about delivery of a deed to a third party. If it's to a third party independent agent, then there can be conditional delivery. This has to be an independent third party agent, and the reason it works is because one of the conditions is that the delivery is irrevocable. We do this anytime we use an escrow agent. We make a conditional delivery of the deed, but that delivery is irrevocable, and that makes it okay. That gives us present intent to deliver.
Mm-hmm.
So what if it should happen that the grantor gives the deed to somebody who is not an independent agent, say to a friend or to a family member? As long as the grantor retains the right to get that deed back, there is no valid delivery. So your issue would be, is this third party independent or is the third party not independent? So, what about delivery presumptions? The presumption, if the grantee is in possession of the deed, there's a rebuttable presumption that the deed is valid, that there was valid delivery. If the grantor is in possession of the deed, there's a rebuttable presumption that it was invalid. If the deed has been recorded, then there's a rebuttable presumption that it's valid, that delivery was valid. Now, finally, let's talk just a bit more about escrow. Escrow is the mandatory depositing of a deed with a third party, and the deed is released upon fulfillment of some conditions.
Normally
usually
just,
payment.
Pay money.
Commercial escrow means that the deed must be irrevocably delivered and the escrow agreement must be in writing. And that's really all you need to know about escrow.
Mm-hmm. Once you get your deed, now don't forget, under the doctrine of merger, you lose all of your rights under the land sales contract, and you must sue under the deed if there's any kind of problem. And remember, there are 3 types of deeds: general warranty deeds, and we're going to come back to this. They contain 6 covenants. Special warranties, that only titles against defects during the grantor's possession. And we've already discussed quitclaim deed. In a quitclaim deed, basically no warranties, no promises, you just give up what you have. So those are the 3 kinds of deeds. And once you get your deed, you're well advised to record it. Now, the purpose of recordation is to protect and to put on notice subsequent purchasers. Now, suppose you fail to record. Does that immediately extinguish your interest? No, not necessarily. But most jurisdictions have recording statutes. These statutes require a grantee to record a deed because it does want to give notice to a subsequent purchaser. The policy is to protect bona fide purchasers for value from unrecorded transfers. And I'm going to show you in a minute how that might happen. Now, we have a general rule which is a little bit cryptic, but let's get it down. All prior interests in land are void if not duly recorded as to a subsequent bona fide purchaser for value. So let's begin. What is a bona fide purchaser for value? We've already been over this. A bona fide purchaser for value is one who acts in good faith without notice of the earlier transaction, where notice can be actual, constructive, or inquiry, for valuable consideration. Now, your usual hypo may go something like this. Dad says to son, "Son, I'm getting old and I'm going to give you this property. Here's the deed to it." And son fails to record. About 2 weeks later, Dad, who happens to maybe not have it all together, sees neighbor and says, "Neighbor, how would you like to buy my land?" And neighbor says, "Sure, let's enter into a land sales contract," and then they go through the time period and they close escrow, and Neighbor now purchases and fails to record. And now, 2 weeks after that transaction, Dad sees another person and says, how would you like to buy this beautiful land? I'm going to actually sell it to you for half price because I need the cash. And again, land sales contract, and then it closes, escrow, and we get another purchaser. Now, let's say the first purchaser records, or let's say the second purchaser records. Who is going to own the property? And the answer is it depends on the type of recording statute. Now basically we have 3 types of recording statutes. Race, which basically means the first to record prevails, irrespective of notice. Pure notice and race notice. Now, in a pure notice jurisdiction, the last bona fide purchaser for value without notice prevails regardless of who records first. Example, Dad gives to son who fails to record. Dad sells to person 1, who is a bona fide purchaser, without notice that Dad has already given the property away to son, who fails to record. Dad now sells to another party, person 2, who has absolutely no notice of anything. So pays valuable consideration and acts in good faith. So is a bona fide purchaser for value without notice. At this point, it does not matter who records. The last bona fide purchaser for value without notice prevails regardless of who records first. So if son records, too bad, the last BFP wins. If person 1 records, too bad, the last BFP wins. However, in a race notice jurisdiction, the first BFP to record prevails. So that's the difference. If it's race notice, first BFP. If it's pure notice, last BFP. So that makes a big difference. And the way you tell if a statute is race or race notice, first of all, how do you know you have a notice statute? You got the word notice in there, in the statute someplace, or something alluding to protection of BFPs, because that's what these statutes are all about. So either the word notice or the word BFP in the statute, you're in the notice realm. And then if you have the words recorded first, first recorded, it's race notice. If you do not have these magic words, then it's a pure notice. So that makes it pretty easy to tell what kind of statute you have.
Now, let me twist some people's minds here. What if we have Dad gives it to son, and Dad, who has some memory and attention problems, now sells it to neighbor, who buys the property without knowing that anything was given to son.
Right.
And neighbor records.
That's the end of the story.
And now father sells to another person who owns Blackacre. Does it matter what the recording statute is?
Not really, because the minute neighbor, the first purchaser, recorded, that provided constructive notice to all subsequent.
So the next purchaser is not a bona fide purchaser for value without notice, which is what you need to keep your eye on.
Right.
There's only one bona fide purchaser without notice in that fact pattern. There's an outright gift followed by a bona fide purchaser followed by somebody who is not a bona fide purchaser.
So remember, recordation provides constructive notice. And as soon as you record, then you could never ever have a subsequent bona fide purchaser for value without notice, because they'll always be on constructive notice. So that's the reason you want to record your deeds. Now, once you record your deed, let's say you've closed the land sales contract. So now, under the doctrine of merger, you lose all your rights under the contract, but you do have a deed. And let's say we discussed the various types of deeds. Let's talk about the general warranty deed that has all 6 covenants, 3 present covenants, 3 future covenants. And these covenants give you legal theories to use under which you can sue if somehow you're damaged as a result of that purchase. All right, now your 3 present covenants under the deed are the covenant of seisin. Now that means that the seller had a true claim of ownership. The covenant that the seller had the right to convey. And finally, the covenant that there are no encumbrances. So let's say after purchasing, after closing on the contract, so you lose your rights under the contract, you now discover a hidden easement. Can you sue? Sure, under the deed, under this present covenant that there are no encumbrances. Okay, now your future covenants run with the land. They include the covenant of quiet enjoyment. This says the buyer will not be disturbed of lawful claims of title. The buyer will not be disturbed by lawful claims of title, which means that, for example, if the buyer prevents the easement holder from using the easement holder is going to sue the buyer, thereby being disturbed by a lawful claim of title. Now, under the 5th warranty and the 2nd future, it's just basically called the covenant of warranty. And essentially what that means is the seller will defend against all claims of title. And finally, under the last covenant, that of future assurances, this covenant says the seller will do what's necessary to perfect title. Essentially then, under a deed, under a general warranty deed, the seller is going to defend and indemnify the buyer if there are defects